of the state of Michigan versus Pamela Ann Rakes, file number 25-22370FH. I have Bert Castleberry appearing on behalf of Ms. Rakes. They are both present in person. I do have a letter dated November 13 of 2025. Mr. Coast, would you like to report on Ms. Rakes and her compliance?
Sure, Judge. She's been on the remote breath machine since it looks like the end of July 30th to be exact. She's done really well with her blows. She's blowing triple zeros.
All right, excellent. All right, Mr. Castleberry, you did receive a copy of the recommendation, correct?
I did, yeah.
All right, so you are Pamela Rakes.
Yes, ma'am.
All right, scoot up a little bit. You need to speak louder, please.
Yes,
Okay, now, you have had an opportunity to read and review the recommendation,
yes, I have.
and you've had ample time to speak with your attorney about that recommendation?
Yes, I have.
All right, Mr. Castleberry, do you wish to explain or challenge the accuracy or relevancy of any information in this pre-sentence report?
Oh, yeah.
All right, and there are no guidelines because it is a misdemeanor. Does the pre-sentence report disclose any prior convictions in which there exists any known constitutional defect?
Oh, yeah.
All right, before the court passes sentence, is there anything you'd like to say on behalf of your client?
Yeah, the only thing I would say is Ms. Rakes, she knows that she has a problem and she has been working on it. She's doing well, as you heard from probation. There is a Killebrew agreement in place, but there's no upfront jail. Other than that, I would ask the court to follow the recommendation.
All right, Ms. Rakes, is there anything you want to say on your own behalf?
Just that I realized that I could have killed someone.
Hold on one sec. I'm so sorry. Mr. Higginbotham, I'm gonna pop you in a waiting room real quick because we're getting background noise and it can mess up my recording, but I'll bring you right back in, okay?
I'm sorry, something had popped up on the screen. I was just letting it
It's
go.
okay. It's okay. I'll bring you right back in. I'm sorry, Ms. Rakes. I'm so sorry, but we need to make sure we get a good recording. So go ahead and continue.
I'd just like to say that, hitting rock bottom the way I did, I'm just very, very grateful that I didn't kill someone. I had no recollection, I still don't. To came to myself in the holding cell and not knowing absolutely nothing. It was very, very traumatizing. And I'd just like to say that I'm just grateful, and I'm here to just take care of the wrong that I did. That's all I have to say.
Well, thank you. And I'm glad that you recognize how much worse this could have been, because a lot of people stand in front of us and they deny responsibility and that they have an issue. So you've done exceptionally well. And I'm glad that you will continue to work on that. All right, so. Sure. Now you are on Social Security, right?
Yes, ma'am.
Okay.
Instead of the 1,500, it's 1,050. That
Okay.
that I seen that was one.
Oh, okay.
Yeah.
Okay.
I don't know if that mattered.
Okay. So. All right, so it is the sentence of the court. You'll be placed on probation for a period of 18 months. So listen, I'm going to order that you serve 5 days in Lenawee County Jail with credit for 1 day. but I'm gonna defer the balance, okay? So if you violate probation, if you consume alcohol, if you do any of those things, you could serve that 5 days or more, up to a year. Do you understand that?
Yes, ma'am.
I'm going to assess, $750 in court costs, a $200 fine, $75 crime victim rights fee, $50 in state costs, $100 law enforcement fee. There is a $30 per month supervision fee and $60 if we have to put you on a tether. During your term of probation, you will attend and complete any assessments or probation recommended. You are required to attend a victim impact panel, attend 12-step meetings. You obviously can't have any alcohol. You can't have it in your home. You're not to use any controlled substances that are illegal. Do you use marijuana?
I'm sorry, no.
Okay. No illegal controlled substances. There will be regular random testing as a term of probation. Search and seizure for controlled substances and alcohol. Understand, for terms of probation, they can enter your premises to verify you live there. If they believe you have some item which would be a violation of the terms of your probation, if they have that reasonable cause to believe that you have that, they can search your house, your car, your purse, whatever else. You are required to sign any releases of information and provide documentation of any medications you take. And I believe that's it. You would have to report, what day do I send them down, Ms. Spade? Tuesday or Thursday?
District Court reports on Wednesdays.
Okay, so next Wednesday, I need you to report to district court probation between 8 and 10. Okay?
Okay,
Because you'll be on probation in district court. And who prepared this report?
Mike Karen.
Mike Karen. So I don't know if he'll be monitoring you or someone else. My bailiff's gonna hand down to your notice of right to appellate review. He's gonna have you initial and date 1 copy for our records to acknowledge you received the paperwork. And then the other 2 copies are for you. And if you wish to appeal your sentence, you would fill out the information on the form and mail it to the address listed on the form within 42 days. And obviously, Mr. Castleberry could advise you on that.
okay.
Hey Pam, you're no longer required to test for me, so you could return that device unless Mr. McCarron wants you to stay on it. Okay, so talk to him about that.
Okay, thank you, Darren, Mr. Cobb.
All right, so you are all set, and I wish you both the best of luck. Thank you.
Thank you.
Record should reflect I received back a
Thank you.
signed copy of the notice of right to appellate review. All right, so from the Wayne County or Wood County Jail, I'm going to ask you to unmute your device and start your video again. Thank you so much. I do have your attorney, and he is going to be logging in just a moment to chat with you. So it'll just be a second. I saw him go in the back room, so I'm assuming he's logging on right now, Mr. Higginbotham.
No rush. I have nowhere to be.
Me neither, so we're good. Mr. Brandt, is your client here?
Yes.
Okay. All right, hold on, just be a minute. All All right, Mr. Brandt, in the matter of the people of the state of Michigan versus Calvin Tyler Isom. File number 25-22248FH.
Yeah, let me get the prosecutor in. I think he went to. Yeah, I do prefer the defendant stand.
I usually have the defendant and the defense counsel stand at the podium. That's a prosecutor's table, so you gotta go on that side of your attorney, sorry. All right,
Judge, I was just sent
Yes.
some victim impact statements. I'm printing them right now.
on which case?
This case, Your Honor, we received them late last night. I believe Donald Boone, who is the listed victim, his brother and sister who have functioned as his caretakers, are present and did wish to read their statements.
Okay,
into the record.
did you receive, I haven't pulled that
John,
one.
I've got a pretty good idea what they are, both probation and prosecutor and I have been. So
I can give you my copy to look at, because I want to make sure everybody's had a chance to review them.
oh, that's okay. You get them last night, you get them last night.
All right, go ahead and have a seat at that table if you'd like, over defense table, and review those real quick.
You had a chance to review the documents.
All right.
Thank you.
All right, so give me a moment. I have reviewed that. So, okay, so, and we're on the record in the matter of Calvin Tyler Isom. We have Alfred Brandt appearing on behalf of Mr. Isom. We have Alexander Bayonetto appearing on behalf of the people. Michael Stevenson from the probation department, who prepared the pre-sentence report, is present in their courtroom. So I have one victim impact statement, and that was the one we received today. There weren't any others.
Okay,
Were there others?
There's actually three.
yes, Your Honor, I think each,
You have one, but.
I reviewed what I got today.
Right.
okay, I have 3 in an email. I'm not sure what you were doing.
Well, I have 1, 2, okay, I guess they were, yeah, but the ones from today, the packet from today. Okay, and do you need a copy of that, Mr. Stevenson? Then? Okay, I'll give you my copy. All right, so, Mr. Isom, step over by your attorney. Have you had a chance to read and review the pre-sentence report?
Yes.
Okay, and have you had an opportunity to discuss that with Mr. Brandt? Yes, speak up louder.
Yes,
Okay, are you satisfied with Mr. Brandt and the advice that he has given you? All
yes, I am.
right, and you also had an opportunity to read the victim impact packet we received today?
Yes.
Okay. Mr. Vianetto, do you wish to explain or challenge the accuracy or relevancy of any information in the pre-sentence report?
No, Your Honor.
Do you, Mr. Brandt?
Your Honor, the only thing so the report itself is factually accurate, correct, as well as the sentencing guidelines. The only thing is that when my client was interviewed by probation, he was in fact unemployed. That is correct.
He is what?
He was unemployed. That is true. Since the interview, he's had a couple of jobs. Today, he's unemployed again because the current employer is understanding that my client will not be available for employment moving forward. So he was employed post-interview. He is not today.
Okay. Does the pre-sentence report disclose any prior convictions in which there exists any known constitutional defect, Mr. Vianetto?
No, Your Honor.
And Mr. Brandt?
No, Your Honor.
All right. And Mr. Brandt said he had no objection to the sentencing guidelines, which were calculated to be 0 to 17 months, which is the straddle cell. Mr. Vianetto, do you have any objections to those guidelines?
No, Your Honor, that was what I calculated the guidelines as.
All right. So, Mr. Vianetto, it's my understanding someone does wish to speak.
Yes.
So,
Your Honor.
Mr. Brandt, you and your client have a seat at that table. Okay, and so, sir, can you state your full name for the record?
Yes, Lord.
Okay. And can you, do you want my copy?
No, Your Honor, I think there was some electronic difficulty from,
I mean, I can give him my copy to read.
he's indicating he wrote an actual letter that was attached to the statements that were given to you.
Yeah, I don't have that.
have those either.
So first, Mr. Boone, can you spell your first and your last name for us?
Yes, DE_Angelo_BOONE.
Okay, thank you, Mr. Boone. All right, so Mr. Boone, your relationship to the victim in this matter?
Holy brother.
Okay, and you would like to read your statement?
Prior to the incident, Donald Boone, my younger brother, lived independently, maintaining his own residency financially. And after the incident, he was unable to continue with his employment, and loss of income contributed to his loss of dwelling, furniture, and his independence. Donald didn't own a vehicle before the incident. Some of the things that I've noticed since the accident was his fear of crossing roads, riding bikes, fear that he would not recover, fear of his legs being unable to bear his weight, fear that he might not be able to return to work at the same capacity. And for a time, he was afraid to attempt traveling upstairs, fear that his legs would give out under the weight, and fear of standing for long periods of time. If I could just add that it took some time for me to be comfortable with Donald living independently, to travel back and forth to work, to be comfortable riding a bike back and forth to work. Donald is autistic with cerebral palsy, and to allow him the space to be independent. Took some time for myself to adjust as well as my family. And the incident was a horrific experience for us to encounter. and to witness him to go through what he had, the trauma that he had to overcome. And it would have meant a lot to the family had the possible party just remained with him and waited for the proper authorities to come and to take care of him and just to assist him during that time. So it's a long road to recovery. He's still not there. We're still working with him. And for him, it's emotional. For us, it's emotional. It's physical impairments. I mean, he's got scarring that he'll have to deal with for the rest of his life. He's got metal in his body that he'll have to endure the rest of his life. And to regain that confidence to live independently. And for us as a family also to regain that. So it's a really emotional ordeal. Even so right now. There are months where I had to carry him up and down the stairs. And even when it came to going outside and going participating in certain activities, he was more reserved and more reluctant. And I think it's gonna have some ways to go to overcome the tragedy that took place.
So I need you to join the breakout room with your, yeah, okay, good. All right. Was there anybody else,
There is.
Mr. Boone, and your family that wished to speak? You can move that mic down, phone down. There you go. Hi, can you state your name for me?
Tiny Sugarloaf,
Can you spell your first and your last name?
Tynessha, last name Boone.
All right, and how are you related to the victim in this matter?
He's my younger brother.
Okay, thank you. All right, go ahead.
Just to piggyback off of what my older brother said, it was just a trying and hard transition from him being in, because it took a long time for him to be independent. He was well into his 20s when he first obtained his first home. He was staying with family and everything before then, and he finally got to the point where we trusted that he was able to take care of himself. For quite a few months after the accident, he was staying with me. At that time, I quit my job to take care of him because he needed hands-on. He couldn't really do much of anything. He couldn't cook, clean, or anything for himself. Barely walking, barely, like my brother said, he used to put him on his back to carry him up and down the stairs. And it's still like just seeing him timid to even walk up 3 stairs or down 3 stairs, walk to a corner. It's been a long time. It's been a hardship for him or whatever. Just seeing him trying that hard to be normal again when he tried so hard to be normal in the first place. It just really hurtful to see that he almost got knocked back down to square one, even though his spirits are higher. His physical, it took a long time to get him back to where he is now. And I just feel like a person that could leave a scene, drag him, because his skin was dragged off his face, drag him like that and leave him there to die never, or not even knowing whether he was okay or not. He lost a lot of everything, like just to see the state that he was in. When we got to the hospital, where he didn't remember who he was or what happened or what was going on. And they rarely could even tell us anything that happened because no one was there with him. No one seen what happened, only just heard from video cameras and things like that. Just to see him doing a little bit better. I thank the Lord for that. But that's, to me, in my words, that's a heartless person that would just leave a person not knowing what happened, what was going on, or to even just sit there until the ambulance got there or came back to see about him or anything. That's a heartless person. Thank you.
Thank you. Does he want to talk today?
He does not.
Okay, all right. All right, you can come back up to the podium. So, Mr. Van Netto, is there anything you want to say on behalf of the people?
Just briefly, Your Honor, we had a bench conference, in this case, I think it was maybe 2 weeks or so before the plea was taken. And this court had indicated that, although it was unlikely the court would send Mr. Ison to prison, you did feel that a jail sentence is appropriate. I think, given everything Mr. and Ms. Boone have said this morning, I still believe that is appropriate. I would ask that you adhere to that and sentence Mr. Isom to a year at the Lenawee County Jail. Mr. Isom has been on bond for quite some time and has accrued additional charges while on bond. I think given that, plus these statements from Mr. and Ms. Boone today, do support a rather lengthy jail sentence. And again, Your Honor, I would ask that the court sentence him to a year at the Lenawee County Jail.
And just for the record, the new charges he's accrued?
He has a possession charge. There was also a second domestic violence case that had popped up while he was out on bond. I know that there's also
Popped up or occurred?
Occurred, Your Honor. I know there's also another charge that's set for pretrial this morning that was to be dismissed as a part of this plea. So again, those are the new charges that have come up since Mr. Isom has been on bond.
The letter that I believe your assistant brought in, was that the letter Mr. Boone had written?
I don't believe so. I looked at the email that Ms. Petty forwarded me. I didn't see it, but I believe Mr. Boone was able to get everything he wanted out.
Okay, I just didn't know if we needed a copy of it for probation. Okay, all right. Anything else, Mr. Van Netto?
No, Your Honor, thank you.
All right, Mr. Brandt, is there anything you'd like to say on behalf of your client?
Thank you, Your Honor. These are the worst of cases we see in that normally in this arena, we talk about intent. Crimes are intent acts by human beings. I intend to rob you. I intend to steal your car. These are cases that are by and large negligence. They are accidents. There is no specific intent. In this case, a young man, my client leaves work, he's headed home. It is at night. What occurred, occurred. I can't turn the clock back at all and say, what were you thinking? What were you doing? It happened. He left the scene, he panicked, in part because of age, maybe. I don't know, but that occurred. The outcome is horrific. My client is deeply remorseful. He has been unable to make that statement because of civil litigation. That's my direction to my client, that he can't make a lot of statements about the incident. My client is well aware of the fact that he is going to be incarcerated and hopes to be a better person moving forward. It is my sincere hope that the victim is able to, at some point, recover from the injuries and get back to his life. My client will have this conviction on his record moving forward that will prevent some employment moving forward. His current employer is not going to keep him. And so there is a price for him to pay. And so we would ask the court to follow the recommendation, and hopefully this young man can get physically back to where he was pre-accident.
Is there anything your client wishes to say in light of the no contest plea or?
Yes.
Okay.
I apologize. No intent. What will happen?
Can you have your client speak louder and towards the microphone?
I asked him to speak to.
I know, I usually like him to speak to me.
I apologize once again for everything. for everything that happened. I know in time of that happening. Sorry, I think. I hope you do end up getting a lot better. Feel better. That's the thing.
So, anything else?
No, Your Honor, thank you.
In determining the appropriate sentence in this case, the court has considered the seriousness of the offense, your history, the principle of proportionality, the statutory penalty, the cost of confinement, the sentencing guidelines, the report and recommendation of the probation department, as well as what has been said upon the record at this hearing. The criteria and reasons for the sentence are the nature and gravity of the offense, the discipline appropriate to its commission, deterrence against repetition by you and by others, potential for reformation, vindication for law, and the protection of society. So, Mr. Isom, I appreciate you have an excellent attorney and everything you said is true, but I would state that you are not a baby. You are 27 years old. I have a son who's 27 and has 3 kids, works 60 hours a week, supports his family. You're an adult. You're not a child. You may not have intended to strike Mr. Boone, but you fled the scene. You helped cover up the accident. You got rid of your vehicle and you did everything in your power to make sure you didn't take any responsibility for what happened to Mr. Boone. Think about what Mr. Boone's life could be like now. A lot of people don't have a family with the means and, you know, the background that the Boone family has to provide help to their sibling. Any other kid could have ended up in a nursing home, an AFC home, but Mr. Boone is so lucky that he has a family that can provide that support, who can leave their job to provide daily care for him. I mean, that's amazing. And he has that, so he's fortunate. But for you, he wouldn't have needed that. You took away a period of his life, and I think he'll get his life back. He's on that road now. He's a strong young man, but you took that away from him. The sentencing guidelines in this case are 0 to 17, which can call for up to a year in jail. It is what we did call a straddle cell. So it's a sentence of the court that you will be placed on probation for a period of 3 years. You will serve 1 year in the Lenawee County Jail. You have no credit, so I'm not going to give you any credit. You must not, during your term of probation, use or possess alcohol, illegal controlled substances, marijuana. You must have a substance abuse assessment done if ordered and follow any recommendations. There will be a curfew of 10 p.m. to 6 a.m. unless you work. Like if you work nights, they'll work it out so that you can go to work. Evidently, there's a domestic case with a Bailey Jenkins. You're not to have any contact with her. Field agents can search your residence at any time for probation supervision. They can also, if they have reasonable cause to believe that you have items which violate the conditions of your probation, they can search your house, your person, and your property. You're not allowed to drive a motor vehicle unless you get permission from your field agent. Do we have an amount of restitution that, I know he didn't have insurance. I don't know what his medical bills are.
I don't think we do, and so I think what you need to do is leave it open.
All right, I will leave restitution to be determined. In the event there are medical bills or expenses such as that, you just need to report those to the probation department. Okay, so $130 crime victim assessment fee, $30 supervision fee for probation per month, $60 if we have to put a tether on you, $750 in court costs, $68 in state costs. Do I need to order a DNA fee or do we already have that?
We will need one.
Okay, so, and there's a $60 DNA fee. Anything I'm missing, Mr. Stevenson?
I don't believe so.
Upon your release from jail, they usually release you at like midnight or some weird hour. The next business day at 8 a.m. you need to report to the probation department. All right?
No.
All right, now you do have a right to appeal your sentence and
Sorry, I'm sorry.
Did you already do them or?
No, I'm
All right, so we have a copy of your notice of right to appellate review. We're gonna have you initial and date, one copy for or for our records to acknowledge you received it, and then there's 2 copies for you. If you wish to appeal your sentence, obviously you have excellent counsel and you can discuss that with him. But if you do, you would fill out the paperwork and mail it to the address listed on the form within 42 days. Oh, yeah, his hands behind him, so I thought he was handcuffed. I'm like, how's he gonna sign it? Come on. Good. Do you want the statement? All right, the record should reflect that Mr. Isom has signed a copy of the notice of right to appellate review. Mr. Degermo, are you ready?
Mr. McCready, the prosecutor on this case.
He's right here on Zoom. He is on Zoom. All right. So this is in the matter of the people of the state of Michigan versus Aaron Cortez Higginbotham, file number 24-22037F8. Mr. Higginbotham, I don't know how they managed to get you here today, but I truly appreciate that they did do that. I have Dave McCready appearing on behalf of the people, and I have Michael Dagger-Margosian appearing on behalf of Mr. Higginbotham. The probation officer who, I have Sarah Tusky. No, I don't know who this is. Joanne Holly, but I don't have her here today, but I have lots of other probation officers here today. So interestingly enough, Mr. Coast had provided a letter to the probation department stating that Mr. Higginbotham was given a year to pay the $71,995.45 in restitution. The balance has remained the same. How long have you been in Wood County, Mr. Higginbotham?
I've been here going on 5 months, ma'am. I've been locked up since the day you seen me, my mom, my grandmother, and my wife. I have not been free. I've been locked up since September the 6th of 2024.
Yep. So, Mr. McCready and Mr. Dagger-Margosian, we did look into it, pretty much just found out because so many people wanted Mr. Higginbotham that he's never actually been out of jail to make any payments whatsoever. So Mr. McCready and Mr. Dagger-Margosian, are you ready to proceed with sentencing today?
We're ready to proceed. I mean, obviously, I will have an argument that the court kind of alluded to, but we are ready to proceed.
Okay, Mr. McCready?
Yes, people are ready.
Okay, so Mr. Higginbotham, I had allowed for you and your attorney to use a breakout room this morning, and I do appreciate your patience this morning. Have you had ample time to discuss the pre-sentence report with Mr. Dagger-Margosian?
Yes, ma'am.
Are you satisfied with Mr. Dagger-Margosian as your attorney and the advice that he has given you?
Yes, ma'am.
Okay. Mr. Dagger-Margosian, do you wish to explain or challenge the accuracy or relevancy of any information in the pre-sentence report?
Nothing in the report, Your Honor.
Mr. McCready, in the report, anything?
No, nothing.
All right. He has like so many pending charges and we're aware of that. And then he has, you know, 1 prior felony to this conviction and 4 prior misdemeanors. So Mr. McCready, does pre-sentence report disclose any prior convictions in which there exists any known constitutional defect?
No.
Mr. Dagger,
None to my knowledge at this time.
all right, before the court passes sentence, is there anyone here on this case that was, I've got a courtroom of people and I don't know what case you're here for. Nobody here on this case that's in the courtroom? No, okay. Mr. McCready, is there anything you'd like to say on behalf of the people?
Yes, Your Honor, there is a sentence agreement here. We did adjourn this a year so he could pay restitution, and I understand that he's been locked up ever since, which, limits his ability to do that. But as the court just alluded to, he's got charges pending all over the place. So I don't think allowing him any more time is going to get us any further down the road. He was initially charged with a continuing criminal enterprise, and the guidelines on that started at 6.5 years, and he could have gotten as much as 16 years with a habitual on the original charge. So he is getting a benefit of a bargain here, even though he wasn't able to come up with the restitution. Essentially what this was a cross-country scam where he and another person who's also been charged, they went to Oklahoma, Tennessee, Texas, Ohio, Indiana, Missouri.
Hold on a second. Mr. Higginbotham, you will have an opportunity to speak, but right now is the prosecutor's. No, it's okay. It's his turn to speak, and then you and your attorney will get a chance to speak, okay? Thank you. Mr. McCready, you may proceed.
So they took real people's information, got false driver's license in all those different states, and presented them at Harley dealerships in all those states, probably 15 different places, and got $500,000 worth of Harley Davidson bikes that they took out loans in other people's names and drove off with the bikes, ruining people's credit. I mean, one after the other. So, and to my knowledge, none of those bikes has been recovered. None of the restitution for those bikes has been paid. The last time I talked to the representative at the Harley credit. So I think the 3.5 years that we've agreed to is an appropriate punishment given the facts of the case. And I asked the court to follow the plea agreement that we've reached.
All right, Mr. Dagmar goes in.
Well, a lot to unpack there, Judge. I guess I'll start with the sentence agreement. I believe it's 3, not 3.5, but
it was 3 to 14.
yeah.
Yes,
so
that's okay.
So as far as that, the other allegations that Mr. McCready references in other states, I guess the court can take into account that for whatever weight you want to put importance on. I'm not sure that those have been. I'm not sure that those have resulted in convictions anyway, but that's kind of beside the point. As the court alluded to earlier, Mr. Higginbotham was initially arrested in Michigan on, I believe, September 6th. And then in looking into this case in district court, he was charged with continuing criminal enterprise. I thought, I don't want to relitigate this case, but I thought that was kind of a skeptical charge, in my opinion. Maybe the reason why we resulted in the convictions, in the 2 convictions that were ultimately offered. Mr. McCready is correct that there was a delayed sentence under 771.1 for Mr. Higginbotham and the co-defendant, Mr. Cooper, it was a joint and several amount of restitution for $71,995 that has not been paid. Mostly the reason is because Mr. Higginbotham has been in custody this entire time. He was released either in district court or Your Honor released him on PR, technically released him on PR on this case, maybe November 13th of 2024, with the intention for him to make the payment of the restitution. But again, by all purposes, it's essentially an impossibility when he's in custody. And he didn't have the ability, financial or otherwise, to be released from that facility to try to make that payment. So prosecutor may say something along the lines of, well, that's his doing, that's his fault, but I think it's appropriate for this court to take into account that he just has not had that opportunity. It's not like the money hasn't been paid because he didn't want to do it, he just didn't have the opportunity to do it. I do recognize that there was a sentencing agreement reached in this matter. That condition has not been met, but I do think it's appropriate for this court to take into account the background circumstances here. And then I guess lastly, what I would say is if the court follows the request of the prosecutor to follow the sentencing agreement, then I would ask the court to, if the court deems appropriate, to give as far as credit on this case from the time, I think because he's been in custody since 9/6 of 24, I think it would be appropriate since then. With it being the PR granted on 11/13/24, I think it would be appropriate from that point on, but I would be asking for the full amount of time, given that he's going to be, if the court follows our recommendation, given he's going to be sentenced to prison, I think that should be counted towards that time, and then he'll be able to deal with these other cases in other jurisdictions.
Mr. Stevenson, as I look through his vast amount of pending charges, I see some VOPs, obviously with sentencing dates before these incident dates. And are any of the new charges offense dates after our date? Is that something you would have picked up?
Yeah, I didn't do the report.
Oh, that's right. I'm sorry.
Okay. I'm not sure.
One of 23, or 4 of 24. So some of these cases that he's facing could have incident dates after our date, so they would stack if he gets sentenced somewhere else potentially. All right, anything else?
No, Mr. Higginbotham, I think probably wants to address it.
Yeah, Mr. McCready, was there anything else you wanted to add?
Well, he's by law not entitled to credit since he has a PR bond in this case. I don't know if that was clear, but other than that, no.
Okay. Mr. Higginbotham, so this is your opportunity now. Is there anything you'd like to say on your own behalf?
Thank you, Your Honor. Yes, I'd like to say that I know I agreed to get in contact with Miss Holly as soon as possible, which would be the next business day of me being free, to figure out payment arrangements. I haven't been able to do that. I've been trying to figure out if my wife and my mom can take care of that somehow while I was still locked up. They was contacting her, letting her know as far as the jails I was moving to once I was done here and there, you know what I'm saying? So they was letting her know what was going on with me. It wasn't until I got here that my, how can I say this? My IRS check came home, and the attorney here let me get power of attorney. I think if that's the word I'm looking for, power of attorney, to sign over my rights for her to be able to cash my check to see what's going on as far as making payments. Because we knew, I figured, to be honest, I thought I had court with you guys like October or something. And that's when I got on my mom and my wife like, hey, we got to figure out something because I'm here. I don't know if they know if I'm here or whatever the case may be. But my wife ended up trying to cash my IRS check and end up really going to jail for it because they thought she was trying to do some fraud stuff. So that took 3 days for me and my mom to try to figure out why I was in here, for my attorney to try to get in contact with someone in Detroit. Why is this lady trying to cash a $16,000 check in someone's name who was locked up? And they didn't believe that I was locked up. So my attorney had to contact Wayne County and let them know, hey, she's trying to do something for her fiance that's in here. So I never got out. Everybody knows that. I never understood, or I mean, not understood. I never got to get an agreement of what payment arrangements I was going to have. But I haven't had my wife reach out to get that information because she wasn't able to cash the checks for me. So I'm just been here trying to finish stuff, get out to take care of this stuff, to get it behind me. I'm not out trying to run from you guys or think I'd have made it scot-free or you guys just let me go. You guys will never see me again. Like I told you guys before, I'm a man of my word. Me and my mom told you in court, I'm gonna get out, I'm gonna make my payments. Because of course, nobody wants to go to prison. Definitely not at this late of an age. So, like I said before, I accept my consequences for what I did. And I apologize to them. You know what I'm saying? The victim, Harley Davidson, for making you guys come in today. So
We're here anyway, Mr. Higginbotham.
I mean, it's good to be here, I'm not gonna say nothing. It's good to be here. Everybody woke up today. But I'm just, I'm hoping for the best. Thank you.
Okay.
May I just very briefly?
Sure.
Something that Mr. McCready said in his last statement of that he's not entitled to the credit. In circumstances like this, where the court's intention was to release somebody to get him out of jail to do whatever they needed to do, if that doesn't happen because of something where he has pending cases elsewhere, I would just ask the court to impose a nominal bond nunc pro tunc from the time of when we I don't know, when we adjourned it or when we changed it on 11/13, which would obviously, so retroactively he would be allowed to get it.
Okay. Mr. McCready, anything you want to add to that? Since I give him, okay. So, what a mess you have gotten yourself into, Mr. Higginbotham. So, in determining the appropriate sentence in this case, the court has considered the seriousness of the offense, your history, the principle of proportionality, the statutory penalty, the cost of confinement, the sentencing guidelines, the report and recommendation of the probation department, as well as what has been said upon the record at this hearing. The criteria and reasons for the sentence are the nature and gravity of the offenses, the discipline appropriate to its commission, deterrence against repetition by you and by others, the potential for reformation, vindication of the law, and the protection of society. Mr. Higginbotham, you have so many cases out there floating around that you're going to have to take care of, and you're going to be incarcerated for quite a while. And hopefully you get all this cleared up and you make some changes in your life that you don't end up back in this situation again. With regard to his sentence, first I would say Mr. McCready and Mr. Dagmar-Gosian, I don't think you were here, but in my past, I have appeared in front of judges who like to give my clients PR bonds when they had charges somewhere else so that they wouldn't get credit. Or, if someone disappears, obviously they wouldn't be entitled to credit. In this case, Mr. Higginbotham did stay incarcerated. He didn't dip out, he didn't take off, he didn't fail to do what he agreed to do. By his own choice, he was incarcerated, and we didn't know that would happen. The intent when I gave him a PR bond at that time was to afford him an opportunity to pay on this restitution, because I remember very clearly he was like, I will legally find a way to pay this back. And so Mr. McCready was kind enough at that time to agree to a PR bond. But unfortunately, Mr. Higginbotham has not spent one day out of the jail since then. So I will retroactively change that bond to allow him to have that credit, because there was no ill will on his part in not following through on that. But at the end of the day, Mr. Higginbotham, this scam costs people a lot of money, and you've got a lot of states that you need to pay to give restitution to, and a lot of people who made losses and probably spent a fortune trying to clear their credit and their name and the business to replace those bikes. So it is the sentence of the court that you will serve 3 years, hold on. Okay, it was 3 years to 14 years with the Michigan Department of Corrections. I will give you credit for 431 days already served. That's my calculation of the time that he's been incarcerated since his initial September 6th of 24 arraignment date. And that's on count 1, the uttering and publishing. Wait a second. No, hold on. So I want to make sure I get this right. So we're sentencing them on 2 counts. Count 1, uttering and publishing carries a maximum penalty of up to 14 years in prison. The guidelines on that one, Mr. McCready, were 12 to 24 months. So on that file, would the sentence be 24 to 14 on that count? And then the guidelines on count 2, state ID card, are 29 to 57. On that one, I would do the 36 months.
Yes, that sounds good.
Mr. Degemer goes in.
I think that makes sense.
Okay, so on the uttering and publishing charge, sentence the court, you will serve 14 or 2 to 14 years with the Michigan Department of Corrections with credit for 431 days. On count 2, state ID card, counterfeit, forgery, and use, which is a 10-year felony, sentence of the court, you will serve 36 months to 10 years with the Michigan Department of Corrections with credit for 431 days. Those will run concurrent. There is restitution in the amount of $71,995.45 to be paid to the Harley-Davidson Financial Services. Crime victim assessment fee of $130, $136 in state costs. That would be $68 per count. And then a supervision fee of $30 per month if you're paroled out, and $60 if they have to put a tether on you. And I don't think I'm missing anything else, Mr. Stevenson. So, Mr. Higginbotham, we're gonna need to send you your notice of right to appellate. Is there anything else, Mr. McCready?
No.
Daggermar goes in, Mr. Daggermar goes in. Sure. Okay, so Mr. Higginbotham, somehow we are gonna send to you your notice of right to appellate review. We're gonna ask that you initial and date 1 copy, they'll send it back to us. The other copies are for you. If you wish to appeal your sentence, you would fill out the information on the form and mail it to the address listed on the form within 42 days. My assistant got you here through your family's contact, so I'm sure we will be able to get that to you. Miss Adams, is there any information you need to be able to effectuate that?
It's just the Wood County Jail, correct? I can look up that.
Yes. Yep. All right. Okay, Mr. Higginbotham, thank you very much for your patience this morning.
You're welcome.
All right, thank you. You're all set.
Thank you.
Thank you. Thank you, Mr. Daggermar goes in, and Mr. McCready, have a good day.
Thanks.
Okay,
You too, Judge.
so Jamie Heimerdinger here? Okay, and Rhonda Underwood, your attorney, right?
Yes.
Okay, and Joshua Johnson? Oh, he's in prison. I don't have the prison. Prison did not show up today. All right, I do, so if someone wants to text Miss Underwood and let her know whenever she is ready on those, I can do that. And all right, Harold Helisek versus Leonard Fritz. Do I have any attorneys on that one? Yeah, I can't hear that.
Yeah, Stephanie Breyer is on behalf of plaintiff, and Attorney Best is just in the hallway with his claims adjuster, so we're all here.
Okay, Well, when you guys are ready, I'll take the attorneys back to the jury room, okay?
I think we're ready. I'll go get him ready.
Okay.
I didn't catch her name, just what you know, Jeff.
Say it again.
I did not catch her name. I didn't catch her name. That's okay.
I can tell it to you right now, though.
I can look.
Her name is Stephanie Fryer
Okay, thank you, Jen.
with an F. He's 73863. Right, Stephanie Fryer?
Yes.
Okay. Mr. Beth?
Morning, how you doing?
So I'll take you guys in back while we're waiting for Miss Underwood.
Yeah. Okay. Okay. Yep. All right, I'm gonna head back. If you need me.
Okay, yes, okay, well, I'll let Becky know.
Okay.
Thanks.
There's 6 patients.
She's like the receptionist.
Yeah. Yeah.
Well, so they gave, so they came in my classroom. Here. And then. Now I'm like.
Oh, yeah, so this is like.
Yeah.
Yeah. It's court is. Or if you're going to one case.
Well, years ago.
Well, these are paper things. I talked about it. We've been trying to fix it for. I almost died.
Happy birthday to you. Happy birthday to you. Happy birthday, dear Kelly. Happy birthday to you. Thank you very much.
Your present.
Your turn.
No, it was just.
Hey, I heard it. Sounds about right.
Charges on voice. I'm being a call to. Where's the name of the
You know what?
She's only got three.
Oh, well, right now it's a, Katie said, I don't know, I'm going to put up, it's on your mail. Yeah. Service nice.
So make sure it's size 7.
No, it's not. So they said, nice service. Oh, man, it takes you out.
It's just old.
It's all the cuts. It's old.
I'm showing my sport and everything.
Thank you.
Thank you. Thank you. Wait, I know this is a good idea. We're all deliberating on that. They'll be right with us.
Oh, I have 2 sons. Yeah. Oh.
Do you need to talk to them?
Please rise for court's now session. May be seated.
I hear they're calling for you in district court, so I'll help you on your way. Come on, Miss Underwood.
I'm sorry.
Nothing. All right, Ms. Underwood, do you want to take do you want Ms. Heimerdinger first? Who do you want to do first?
Are they both on Zoom, Your Honor?
They're right here.
Okay.
I will tell you, Joshua Johnson is not here.
Is he on Zoom?
No,
Oh, so we won't have him.
I don't think so. He's an MDOC.
Right.
So if you want to go talk to Ms. Heimerdinger, go ahead. So raise your hand if you're here for Heimerdinger. What are you here for? Who?
Assault for Chris Regaldo.
Okay, that's at 9:30. Okay.
Yes.
All right. Okay. So are you Garrett? How do you pronounce your last? Zeman and Chris. Okay, so I'm gonna call the case. You're gonna come have a seat here and you're gonna have a seat here. So this is in the matter of Garrett Zeman versus Chris Regalado. File number 25, come on up. Yep, file number 25-53048. Okay, so. Excellent, everybody have a seat. Okay, so we are here today. Yeah, are you ready, Ms. Underwood?
Your Honor, with apologies to the court, we discussed her PVR, but I'd rather borrow your copy so she can actually see it.
Of course.
Let's go
Okay.
downstairs and get it up on the screen.
Yeah, you're not allowed to go on the first floor till I'm done with you. All right.
What?
Hard to catch.
I know. Okay, so we are here today on Mr. Regalado's request to terminate the PPO. So can you both raise your right hand? Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth? Mr. Zeman?
Yes.
All right, and Mr. Regalado? All right, so put your hands down. All right, so. Okay, so Mr. Zeman, you had filed a petition for a personal protection order back on, let me get back there. On October 7, I believe, or was it October 6? Yep, October 6. And at that time, you alleged that you were in fear of Mr. Regalado, that you had taken your dog outside and you found some couches on your property, right?
Correct.
And where were they? Like they over the line or on the line or?
They were over the line.
Okay, and you stated that 3 months before that, so sometime in the summer of 25, Mr. Regalado had threatened you.
Yes.
And what was that threat?
That if I wasn't disabled, he would kill me in a fight.
Okay, and the police came that night?
Yes, they did.
Okay, and did they interview you?
They talked to me and they told me they couldn't really do anything because it was just words.
Okay, and now you live, is it just next door to him?
Yep, I live in 340 James River Boulevard and he lives in 339.
Okay. All right. And you stated that you are legally blind and you have cerebral palsy. Is that correct?
Correct, and I had radical brain surgery. I had 3 strokes in my mom's stomach.
Okay. Okay. And so you went back in the house with your dog and you asked your mom to help you move furniture off of your, is it a duplex you live in?
No, it's mobile homes,
Okay.
trailer parks.
Okay, all right, so you went in and asked your mom to help you move the furniture,
I did,
and you guys pushed the furniture onto the driveway near the street, is that correct?
correct.
All right, and Mr. Regalado came out of the house at that point.
Yes.
So tell me what happened at that point.
So he came out of the house, he did jump off the porch, and it just escalated out of control when he didn't even let me get a word in edgewise. And all I wanted him to do was move the couch off the property because we just bought, and we get charged for anything that is wrong with the yard or anything like that. And it rained poured the night before, and ruts or anything that put in the yard, we had to take care of. I'm on a limited income. I'm on Social Security.
Okay, so we're gonna pause. Miss Underwood and Miss Heimerdinger, can you go stand at the podium? We're gonna pivot here, Miss Spade. So you guys stay where you are for just a minute. All right, in the matter of the people of the state of Michigan versus Jamie Marie Heimerdinger, file number 25-53048PH. I have Rhonda Underwood appearing on behalf of Ms. Heimerdinger. Both parties are present in person. This is the date and time set for sentencing on a probation violation. Ms. Underwood, have you had time to review the probation violation recommendation report with your client?
Yes.
All right, so Ms. Heimerdinger, have you had enough time to speak with Ms. Underwood about this report?
Yes, I have.
All right, are you satisfied with Ms. Underwood as your attorney and the advice that she's given you?
As of up until right now, just until some recent, when I was here last time and I pled guilty to this case, I was told that there would be no jail time regarding this case.
And who told you that?
She did. You guys went in the back and talked about this. And then came back out.
Okay, so Ms. Heimerdinger, you understand this is a recommendation?
Yes.
I'm a judge. I can do whatever I want. I could send you to prison if I wanted to today. I could give you jail, or I may continue your probation. Do you understand that?
Absolutely.
And I'm gonna guess that there were discussions about what we were gonna do on this, and you have now paid all this off, correct?
Yes.
Okay, since the date I arraigned you,
Yes, ma'am.
because that's what I asked you to do.
Yeah, everything has been paid off.
Right,
Yes.
okay, all right. So what does that have to do with whether or not Ms. Underwood has represented you? Has she given you legal advice?
Yes.
All right, and was it appropriate legal advice?
Yes.
Did she review the pre-sentence report with you?
Yes.
Was she respectful to
Please
you?
speak up.
Yes, yes.
Okay, all right. So are you ready to proceed to sentencing? Ms. Underwood, is there anything you'd like to say on behalf of your client?
Very much so, Your Honor. Ms. Heimerdinger, as she said, has made significant efforts and paid off fines and costs. Ms. Heimerdinger is employed. Where are you employed?
Cement City Market.
Cement City Market. She's working. In addition, Ms. Heimerdinger has been on colors, Your Honor, and I believe has been clean on those colors.
She has not
The
been
results
clean.
are here, but
Hold on, Ms. Teskey?
She has not been clean, Your Honor. She has tested positive numerous times for marijuana and alcohol. With the last, I can bring up her drug screens. She has not been clean.
Is alcohol and marijuana a term of her probation she can't use?
Correct.
I'm sorry, Your Honor, it's alcohol, marijuana.
I started dropping clean the last time you were in. I stopped smoking weed when I went.
Speak up louder for me.
I stopped smoking marijuana when I started reporting. I started dropping clean the last time that I was in your courtroom on October 10th. I think there was 2, maybe 3 dirty marijuanas, but I have been clean since then.
All right, Ms. Underwood, you may proceed.
At any rate, Your Honor, she's making strides. She's paid money. She's done things we want probationers to do. I don't think jail time in this matter is warranted, Your Honor. Let's continue her on probation and have her complete and show Ms. Teskey that she can get this done.
So Ms. Teskey, I think the confusion is Ms. Walsh or Ms. Teskey, it said that her drug testing results were attached, but they weren't on my packet. So I'm sorry about that. That's probably where that confusion came in. So the last time she tested, was she clear?
So yeah, she's finally clean, Your Honor. But from 8/19, when she originally, I ordered her to do colors, she was positive consistently for ETG and THC until 10/13. All the while reporting to me, I explained to her she has to, I mean, are you drinking alcohol? She denies use. I have positives that indicate that she was drinking. We can't just extend her, we can't just keep her on probation. She's way past her max date because of how long she absconded. I haven't been able to verify the city market job. She hasn't brought me a check stub. She hasn't brought me any of that. I do believe that there needs to be a consequence for absconding for as long as what she did.
I thought absconding was dead time. And I could extend her probation because we don't count that 3 years.
I mean, I guess we can, I don't know.
I've always, and you know, nobody else, I just looked at Mr. Stevenson, but he's not here. It was my understanding if somebody absconded, that's dead time. And so I can't extend their probation or continue them on probation.
Okay.
Pretty sure, let me see here. Let's see. I know Mike's here, maybe he can ask. Hi, I'm on the record with Sarah Teskey, and I remember a case where somebody absconded for like 3 years from probation. And because they absconded, that's dead time. So I can still continue them on probation no matter.
Yeah, you can add that time.
Okay.
Yeah, we've done that before.
Okay, thank you.
Yep, you're welcome.
Bye. All right. So. So Ms. Teskey, she absconded like, what, 90 days after being placed on probation?
Let me look
here. Looking, she was placed on probation in February of 22 and absconded in June of 22 and was gone for 3 years. Okay, all right. Anything else, Ms. Underwood?
Just that Ms. Heimerdinger has a stack of letters from character attestations, Your Honor. And a courtroom full of people, or significant support here in the courtroom, Your Honor, we would request that Ms. Heimerdinger be given 1 shot at probation, Your Honor.
Ms. Heimerdinger, anything you want to say on your own behalf?
Absolutely, I do. I have a letter I'd like to read.
Okay.
Hello, Your Honor, people of the court, and anyone else listening today.
My name is Jamie Harrier, and I'd like to address the court, not as an addict, not as a convict, not as a felon, but as a human being. A human being who has made plenty of mistakes in her life. Since my early days, I have been in and out of the system, rehab, prison, and jails. I have seen my kids taken from me. I have burnt bridges with people that I love the most. And here today, every one of them sits in this courtroom. The depths of my support have gotten me where I am today. I have made mistake after mistake after mistake my entire life. I have been to my lowest point a person can go, but I stand before you today as a mother, an active member of my community, a sister, a friend, and a daughter. For decades, I roamed with no direction. I lost sight of what was most important for many years. Today, I stand before you as someone who has direction and meaning. A single mother trying her best to take care of her children, an employee trying to show herself and the world she is worth something. I stand here today as a woman whose past does not define her. Since April 14th, 2022, I have been clean from any and all drug use other than the occasional marijuana for medicinal purposes that I have also quit entirely. Heroin being my biggest accomplishment of all. Something I chose to do 100% of my own regard, not because I had to or was made to, solely because I wanted to. I have been an active participant in my 5 children's lives, including my newly born infant. I showed the court that dedication to both responsibilities on August 13th of this year when I was in your courtroom via Zoom 4 hours after giving birth to him. I have maintained random drug screening, paid all fines and court costs up to date, reported in a timely manner with nothing but accomplishments. My life has more meaning now than it ever has. I have learned from every one of my mistakes in life. I have grown into someone my family, my friends, and others can depend on and be proud of. Your Honor, I am doing my absolute best to live right. Things have been going well for me despite what you may have heard. My life finally has direction, and I beg you to let me continue to show everyone, including myself in this court, that I continue to improve. Despite the recommendation of a year in jail takes me away from my children who need me and all the hard work that I put into the past couple of years, and only proves to add yet another year of adversity to my life. In closing, Your Honor, I understand whatever decision you make, I will respect with integrity. I just hope that it's a decision that can allow me to prove to everyone I can be a respectable member of society. My children need me. I am finally the mother they have needed for years, and I beg of you to please not take that away from me or them. Thank you sincerely from the bottom of my heart for everyone involved today.
Thank you. All right, where are you working?
Cement City Market.
Okay, and it's a grocery store?
It's it's a little party store. It's
How often
Cement
do you,
City.
how many days a week?
4 days a week. I work Saturday, Sunday, Monday, and Tuesday. When I went and reported.
Wait, you work Saturday, Sunday, Monday, and Tuesday?
Yes.
Is that every week?
Yes.
Okay.
I just recently started there. This past week was my first week. When I went and reported last time, I told Miss Teskey that I was employed.
Saturday, Sunday, Monday, Tuesday. What time do you go into work?
Sunday or Saturday and Sunday, I work from 8 to 4. Monday and Tuesday, I work from 4 to 9.
What days you work 4 to 9?
Monday and Tuesday.
Okay, and then. Okay. So you don't work on Wednesday, Thursday, or Fridays?
No.
But you're going to work at 8 AM on Saturday?
Yes, ma'am.
And you work till 9 on Tuesday?
Yes.
Okay. All right, so. Anything else?
Your Honor. Your Honor. Ms. Humdinger has people who would like to speak for her before.
All right, anything else you want to say before sentencing? We don't do that. So,
Thank you.
all right, so it is going to be the sentence of the court that your probation will be continued for a period of 3 years for that original 3 years. So obviously you reported for 3 or 4 months, so it would be deducted from that. Here's what I'm gonna do. And listen to me. I am gonna order a jail term, but I'm gonna order you serve something and suspend the balance. Do you understand that? So I'm gonna order that you serve 6 months in jail, but I'm gonna suspend all but 48 hours. You will report to the Lenawee County Jail on November 26th, which is a Wednesday at 8 what time would be a good time? 8 a.m.?
Yeah.
At 8 a.m. on Wednesday, November 26th, you will serve 2 days. You'll serve Wednesday and Thanksgiving Day. I'm sorry, you got to pay for this somehow, right? And then you'll be released. You should be released by,
Do 48 hours, she'll do the full 48 hours.
yeah, so Friday morning you'll get released. That way you'll be able to go to work that weekend, okay? And so you'll serve that 48 hours starting November 26th. And obviously you paid off the majority of your fines and costs. You still have supervision fees of 880 that have to be paid. And I expect a monthly payment to be set up for 12 months to pay that off. So I realized you had someone pay this off for you, okay? That's kind of a history for you. Like you have people help you, but you don't actually do it yourself. And I'm glad to hear that you're in a better place, right? You know, you have to be in a better place where you're responsible for your mistakes too, okay? So you made a lot of progress. I'm glad to hear it, but you do have a history of abstaining from probation, violating probation. Your original sentencing guidelines were, what were her guidelines on this? Ms. Teskey, looking.
Your Honor, they were 0 to 9 months.
So, you know, understand you're still gonna face that. You're in jail if you violate probation. So you will face it up to a year in jail if you violate probation. You understand? So you're getting a chance to prove to us all the things you just said. Okay? Obviously, if you do well, Ms. Teskey will be able to release you halfway through.
Can I request a different probation officer?
No, I don't do that. That is the state of Michigan, the Michigan Department of Corrections. They don't work for me. I'm sorry, sir, you got a problem? Okay, well, you're not a part of this proceeding, so you be quiet. Can't be quiet, you can leave this courtroom. Listen, your behavior is reprehensible in the past on probation, so I could see where it might be difficult to have you as a probationer. But if you do what you're supposed to do, no one's gonna give you any grief, right? You wanna leave too?
No.
Then be still and be quiet. So I don't have any authority over the Michigan Department of Corrections. They don't work for me. I don't work for them. So, sir, I'm gonna hold you in contempt. You wanna go to jail today? I don't wanna chase them, but, you will, Ms. Teskey, when do you want them to report?
I want her to report next Tuesday at 8 a.m.
So you report next Tuesday at 8 a.m. And then you do have a right to appeal this sentence. My bailiff's gonna hand down to your notice of right to appellate review. Initial and date, 1 copy for our records so that we know that you received a copy of it. The other copies are for you. If you wish to appeal your sentence, fill out the information on the form, mail it to the address list on the form within 42 days. All right, So you understand you need to report to Lenawee County Jail on November 26th at 8 AM for 48 hours. Okay.
Thank you.
All right, and report to Ms. Teskey Tuesday morning at 8 AM. Record should reflect I received back signed copy of the notice of right to appellate review.
Your Honor, how are we going to deal with Mr. Johnson?
So in the matter of the people of the state of Michigan versus Joshua Michael Johnson, file number 25-22185FH. Let me see where he is. I know he's not here. Let me see if I can find him on Otis. Yes, I'm gonna see. There's like a really good comedian named Joshua Johnson. Doug, like he watches TikTok, so he knows what I'm talking about. Let's see. Oh, there's so many Joshua Johnsons. So let's see. Miss Adams, do we know
Judge,
his?
I'm not seeing a writ was done, so I just did an adjournment to December 5th.
Okay, what day would you like to adjourn it to?
Judge, I did December 5th at 8:15.
How about December 5 at 8:15?
That's fine, Your Honor.
All right.
I believe that concludes my docket with you.
It does, and I do believe Judge Shadler has been calling for you, but I wasn't gonna let you go.
I'm expecting to be taken into custody from the moment I get off the elevator,
Okay.
so.
Well, we
I hope
will
someone
post your
has-
bond for you, okay?
Thank you.
Because I'll probably need you back up here. All right. Okay, so gentlemen, thank you for your patience. All right, so, okay, so then Mr. Zeman. Okay, so let's go back to. All right, so Mr. Zeman, so you said he jumped over the porch and he came up, and then what happened?
So there was confrontation, there were words said, and I was pushed 3 times.
Okay, so he physically laid hands on you and
Yes,
pushed
he
you?
went like this 3 different times.
Okay, and he physically touched you? And you said he called you names, pussy, bitch, faggot, multiple times? Okay. And was anybody there with you at the time this occurred?
My mom, she's sitting over there.
Okay.
And his wife.
Okay, and so you stated that you have a seizure condition. That physical assault, did that put you at risk of a seizure?
Yes, it did.
Okay.
Because I didn't go to the hospital because I'm not grandma anymore, but I've had a couple seizures in the last 24 hours.
Okay.
Because I'm under a lot of stress since this whole situation.
Okay.
I am actually terrified to even go in my front yard anymore.
Okay, were any charges pressed against Mr. Regalado?
They told me I would have to come to court. They just told me I should file for a protected PPL. And I did it the next morning.
So do you now have cameras?
Not currently, I'm waiting for them to come in the mail.
Okay, okay. All right, and since the PPL was put in place, have you had any? Mickey Mouse ears. I do. Thank you.
I showed you.
All right, so, Mr. Zeman, okay. So since PPO was put in place,
He would wave and stuff, but no like talking or anything.
okay, all right, and come on your property. Okay, now you own or rent?
I own.
Okay, all right, so, Mr. Regalado, I already swore you in.
Am I allowed to stand while I speak?
Wait,
Am I allowed to stand up while I speak?
No.
I have to sit down? Okay.
all right, so, Mr. Regalado, you've been sworn in. So, Mr. Regalado, why are you guys all good?
I'd like to just.
She wants to put out, right? We got it done.
We got it done, I just want to put it on the record.
What done?
Yes.
Oh, Okay, so, bear with us for just a minute. So Mr. Regalado, all right, so you were properly served with a copy of the PPO.
I was, yep.
All right, and,
With
you're,
disappointment,
huh?
complete disappointment. Because
Can you not talk over me?
that's all right.
Okay, so you were served with a copy of the PPO on October 8th of 2025. And then you timely filed a motion to terminate the PPO.
Yep.
You stated that this is false pretenses. You know, false pretenses is a theft crime.
I didn't know that, but it is
Okay,
complete false.
so then you said these people are dangerous, determined, angry.
Yes.
Calculated.
Sir, please look at your.
Again, so
I'm sorry.
if this is how you act with your neighbors, stop. Okay, calculated, disruptive, I can't begin to elaborate. For the sake of space, an unbiased hearing is completely necessary. Okay, so on the day that he alleges that he went to move furniture off of his property, what is your version of events of what occurred, and speak loudly?
It was a Sunday night. The Lions were playing the Ravens. They were kicking their ass. I was in a really good mood. My wife had just ordered couches for the week. We were really close with the office manager because my wife's mother owns a cleaning company. We clean all the trailers out. We're in really good standing with them. The lady told us to get these slips and on Sunday night, put them on the couch, set it out to the road where the trash always comes and picks up the couches. I set the couches where our trash always goes. We do have a property line. We've had issues before where they came and they got spray paint and they marked the property line. It was not bleeding over at all. And the thing is, when I walked outside, it was probably 11 at night. The game was almost over. Everyone's sleeping. Their windows are always open because they eavesdrop, they listen, they just do. I won't elaborate, but they do. We set the couch out. It was commercial break. Went back inside. We did put stickers back on. She's like, let's go back outside. I said, after the commercial. We go out there. The couches are flipped over. They're not moved. My wife has a $40,000 brand new car. Flipped it over, hit the whole back of it. The thing's hanging off. And it's like, in his paper, he said he's fearing for his life. Tell me, is someone fearing for life? Do they go out and flip couches over and hit people's property? Does that sound like someone who's afraid?
Did you call the police and report property damage?
But here's the thing, I didn't know it was them, but when I walked outside and saw the couches flip, I saw the window open and I knew deep down, I knew it was them. My wife obviously said, leave it alone because she doesn't like to engage on it. We just ignore them at all costs. But I sat on my porch because I knew they'd be right back out. I sat on my porch 5 minutes later, it wasn't even 5 minutes. Can I just please stand up for a minute? I want to show you how they came out of their house.
As long as you stay where you are.
They came out, like, they didn't come out calm and like, hey, let's move. They came out all like ready to get it going. And I was sitting on my porch. And they didn't see me because my porch kind of is raised up. And I said, hey, I know you're not gonna flip that couch over again. And what did she say? Get it off my fucking property, all snaggy. It wasn't even on their property line. And the fact is, it's like, I would move it if the principal would come to my door, knock peacefully, hey, it's intruding, can you move it? Flipping it over and hitting our car at 11 at night, what is the sense of that? Within 5 minutes of me putting it outside. And then 5 minutes of going back inside, they're back out, flipping it over again. That's crap. So I got mad, so I said, you guys aren't flipping over, we got into a war of words. He was yelling in my face, and you see him, he's a little bit bigger. His mom knows his condition. Apparently he has cerebral palsy. Apparently he's blind. I don't know if that's true or not, but anytime she's in danger or we're in a war of words, she calls him like a lapdog. That's not protecting your son. And then he gets in my face. He puts his weight on me. He wails his arms. My kids are in the door. They're crying. He's like, I'm not afraid to fight you, man. Jared.
Hey,
like,
don't look at him. Look at me.
He said that all the time. And my daughter's crying at the door. And like, I tell my kids, we stand up to bullies. Like, you're not going to come on my property and wail on me, be on me. So I pushed him back. I kept telling him, Garrett, get out of my face. I'm not afraid to fight you, bro. I got kids. He yells, he's aggressive, he's reckless. So I pushed him back. I didn't throw hands, I just shoved him back. And it was one time. And he stumbled back. And what did he do? He came right back in my face again. At that point, his mom called the cops showed up. We digested all of it. And they even said, if you're going to yell in another man's face on his property, wail your arms, you're going to probably get pushed. I didn't assault him, but like, is that right to flip my couch over and hit my wife's car, who's an innocent saint? She doesn't feed into any of their stuff, but they stalk in their windows. They drive around the neighborhood so slow. They flip off my kids who are 5 and 4 and 11. And they say, if you slid down the hill, we're going to call the police on you. Every time there's something wrong with their house, they blame our children. And not just our kids, their hell knows no bounds. They yell at the neighborhood kids. Everyone, it's just frustrating. Like, that's why I'm so frustrated, because it's like, we don't know what to do with that. Like,
Do you have cameras at your house?
we do.
Do you have cameras of this incident?
The thing is, so our cameras, it's a subscription to pay to actively film all day.
Right.
So we can only film if we log onto the app. It doesn't film all day. So like of them doing it, it's not on film now. My wife has a video of him in my face yelling at me though. And even with me pushing him back.
Okay, so, all right.
But I never got in his face. And the
Does
thing
your
is,
wife work during the day?
yes,
Will she be able to come as a witness for a hearing?
yes.
Okay. Do you have any other witnesses? Yeah, your
It's-
mom, okay.
It's me and my mom, and I did not.
Hold on, I'm not,
Okay.
hold on, everybody, hold on. So, all right, so it looks like we need time to call some witnesses, your wife and his mom. So, Miss Adams, I'm looking for like an hour. Or you can bring me the book, one of the two. Everybody just calm down. We're gonna not take any more testimony today, and we're gonna
Oh,
set it
nothing
for,
else?
we're gonna set it for an evidentiary hearing, and then we're gonna take testimony, because I need more than just you two, I need your witnesses, right? Because,
I would say like, I went to.
hold on, hold on, hold on. Is there a day of the week your wife does not work?
I mean, any day would be fine. I don't work Wednesdays, so that'd be good for me. I'm a beer distributor, so I'm on the road all the time.
But you don't work Wednesdays? So I have CSE jury trial, so I can't do that week.
Push.
Miss Iddings, have you settled Coleman?
Okay, I'm sorry, what judge?
Coleman on December 17th. Are you gonna need a full hour and a half, or have you settled that with Mr. Noe?
It's not settled yet. Unfortunately, I wish.
What about Deaton?
Not settled either.
All right, so I'm gonna set this for 3:30 on December 10 for 1 hour. And so, Ms. Adams, could I get a notice of hearing for 3:30 on December 10? So you're gonna bring your wife and you're gonna bring your mom, and those are gonna be your witnesses. There was nobody else there, right? Okay, so, Ms. Adams, if I could get a notice of hearing for both of them. And we will continue this on that day. So you go back and have a seat over there. You go back and have a seat over there. We'll get you your notices and we'll be back on that
You
day.
can't say anything else?
Well, not
It's
at
not
this-
really related to the case, it's more so like with him.
No?
Like, he's a.
Okay, from going forward, I don't want you guys looking at each other, talking to each other, breathing at each other.
Even if it's
We're
like from a place
continuing
of
this
peace.
to December 10. I'm done today
Okay.
because we need someone other than you.
I just don't want him to be afraid because I really. Like, Gary, you don't have to be afraid.
Hey, that's a violation of the PPO and I completely get it. Use your brains. I don't want you guys looking at each other, talking to each other, snooping on each other, nothing.
Can I ask you a question?
And
Please, if I feel like they're, because like.
call the police. If they're violating the PPO, call the
Even if it's not
police.
related to PPO, like more so like sometimes I feel like they're rooted in looking for chaos. Like they want to judge you and oppress you and they want.
Pray for their souls. I don't know what I can do
No, I
about
know,
that.
but I'm saying,
I'm done with this hearing. I've got to move on. So we're gonna have testimony from witnesses. Everybody behave themselves. All right, so. Yeah, you gotta wait for your notice. So have a seat back where you were, or right there. Yep, okay, so, I don't even know if I have your file still. All right, so back to, in the matter of Harold Helisick and the Fritzes, file number 24-247479NO. Counsel, can you identify yourselves, starting with plaintiff's counsel for the record, along with your P number?
Good morning, Judge Stephanie Fryer for the plaintiff, P73863.
Please speak by the microphone.
Oh, sorry, yeah. Stephanie Fryer for plaintiff, P73863.
Thank you.
Good morning, Your Honor. David Best on behalf of the defendant, P number 63627.
All right, so we scheduled a trial day. We are ready to go, and this case is settled. So why don't you go ahead and, do you want your client to come up, or? Do you have your adjuster still here, or?
I think she's still here, but.
You don't need her. Okay. All right, have your client have a seat over there. So it's my understanding a settlement has been reached, so go ahead.
That's correct. Yep, the case is resolved for $100,000.
All right.
And, defense is going to provide me with a release with standard language, and we will get that signed and executed. And
We agreed with the settlement of $100,000 inclusive of all costs, attorney fees, and the plaintiff will be responsible for any subrogation interest, liens, statutory or otherwise, which will be included in our release. The total is $100,000. And he agreed.
All right. So that's wonderful. I will take the trial off the book now. So we'll set aside that scheduling order, and I will sign that upon presentation. And do you need to come back or anything, or are we good?
No, just on the next one, Judge.
All right. See you on the next case. Thank you both.
Might come back for that next hearing.
Okay. Never a dull moment. All right. Thank you all.
thank you.
Bye-bye. All right. Nope, the case is already done, so you can ask a clerk, but I can't talk on the record about a case once all the parties aren't here.
Okay.
So maybe my bailiff can come over and see if it's just a technical general question. Don't talk to me anymore, please.